This week in the Boardroom, brought to you by NYSE Governance Services Corporate Board Member, along with Governance Knowledge Partners, the Center for Audit Quality, and Grant Thornton, and contributing partners, National Investor Relations Institute, and the Society of Corporate Secretaries and Governance Professionals.
Welcome to this edition of This Week in the Boardroom. I'm TK Kerstetter, Chairman of NYSE Governance Services, and it's my pleasure to welcome you to the show today. And as usual, we've got a great topic. We're going to be looking at sort of the legal landscape in today's boardroom. And with me is a longtime friend, somebody that we've had on the show before, and it won't be your last time, I'm sure, but please welcome Bill Chandler, who's the former Chancellor of the Delaware Courts, Court of Chancery, and also a partner with Wilson Sonsini. So, Bill, welcome.
Thank you, TK. It's a pleasure to be here.
And as usual, we're going to have to talk first about the Delaware Courts since they play such a significant role in sort of what happens in the boardroom and all the significant cases that sort of determine how people are going to operate. So I guess my first question for you and for the audience is sort of what's new? What's in the Delaware Courts that board members at least should be mindful of?
Well, there's been a lot of activity in the past 12 months in the Delaware courts, and I think I might lead off by just mentioning that there's been some change in personnel in the courts. We have a new Chief Justice of the Supreme Court in Chancellor Leo Strine, who was elevated from Chancellor to Chief Justice, and now we have a new Chancellor, Andre Bouchard, who's in office, and we now have a new Supreme Court Justice. In the departure of Justice Jacobs, we have Karen Valahura has been nominated to replace Jack Jacobs on the Supreme Court, and if she's confirmed, she will be added to that court. And Justice Berger has just recently announced her retirement, so we have some personnel changes. But I think the good news, TK, for the corporate world is that the folks that are coming on board as the replacements are all very highly skilled, very knowledgeable in the area of corporate law. And so I feel very good about where Delaware is and going in the future. As well as those personnel changes, though, there have been a lot of sort of developments on the legal landscape. So if you want, I'll just sort of tick off some of them, what I think are the major themes. And I'll start with the letter A. This is sort of like the ABCs of the alphabet. So A stands for activism, and in this case, Allergan. Right now, there's litigation involving Allergan and Pershing Square's effort to take control of Valiant. And there have been decisions recently with respect to activists trying to take positions in companies. There was the Sotheby's decision by the Court of Chancery just a couple of months ago, which I think sort of added to the toolkit potentially that companies can use in dealing with activists. There, the court said you could use a poison pill to effectively deter the activists' effort to take over control of the board in that case. So that's sort of under the letter A. Under B, I might list bylaw litigation. There's been a lot of that. First, about a year ago, we're now on I think the 1-year anniversary of the Chevron decision, where the Court of Chancery upheld the validity of forum selection provisions so that companies can adopt bylaws that choose a particular forum. And the good news is that after a year of that decision having been made, a lot of companies have adopted these. And the even better news is that other jurisdictions have honored them. They have honored the Chevron decision and have ruled that these are also valid and that the litigation should be concentrated in one jurisdiction, whichever jurisdiction the company chooses to have it in.
And in its simple form, just so that people understand that selection issue, in the past, cases could occur in a lot of different districts. It meant multiple trials or cases, and in this case, what it does is lets you focus on a specific district. Is that correct?
That's precisely been the problem of multi-forum litigation, where a company that's sued derivatively because of some error or harm that occurred at the company might be sued in 4 or 5 different jurisdictions at the same time and have the defense costs of defending all of those. If they're involved in M&A activity, I think it's like 97% of all deals are challenged, and they're challenged in at least 5 different courts. And so this would enable companies to concentrate the litigation in a single venue or forum. and save all those costs and expenses. The other part of that, though, the other part of the bylaw litigation that I'd mentioned is the recent decision by the Delaware Supreme Court that would allow companies to adopt fee-shifting bylaws, potentially. They did that in a very narrow way, however, in a non-stock corporation. And I think there's a lot of reason to take caution about applying it broadly beyond what maybe the Supreme Court intended. But potentially it could mean that companies could use that as a way to deter frivolous litigation by having a loser pay rules. And so that's the other part of the bylaw litigation that I think is noteworthy coming out of Delaware. Sort of under the C category of the alphabet would be controller litigation. We've had decisions that now when controlled companies are going private, you can get the business judgment rule treatment for that transaction if you structure it in a certain way. And this was what is known as the MFW decision by the Delaware Supreme Court, that it basically told companies that are controlled companies, if you set up a special committee that is appropriately designed with power to negotiate and say no to the transaction, and if you allow the minority to vote to either approve or disapprove the transaction and give the minority full information and don't coerce the minority shareholders in any way, then the controller can do a transaction like this and get business judgment review rather than the more onerous and more stringent entire fairness review. So that's a very big development potentially for controlled corporations.
And hopefully most people know this, but let's not assume that. It's important that everybody that watches this show or everybody that serves on board understands the business judgment rule. Do the short version of the business judgment rule just so that we can make sure everybody's on the same page.
Well, that's the standard of review that the court applies to decisions or actions by a board, and that's the standard of review you as a director want the court to apply. It's the most deferential standard of review. It presumes that directors have acted fully informed, in good faith, and honestly in the best interests of the corporation. And unless an attacking shareholder or someone else can show some facts to cause the court to doubt that, then the court's going to defer to the judgment of the board. It won't second guess the board's decision or action taken. And that's the standard of review you as a director want to be applied.
Yeah, because it says you can make a mistake in the sense as long as it's an informed mistake.
Correct.
That you have made an effort to do that. So it isn't doing the Monday morning quarterback saying now, we're going to second guess what they're, except if, and this is very important, if the board makes no effort to be informed, you or any of the current judges would immediately say there has been no effort, I can't invoke the business judgment, and this is going to go ahead on a trial basis.
And then at trial, you, the director, will have to demonstrate that your decision was fair and reasonable, which is going to be a much more difficult burden for you than if you had the business judgment standard applied at the outset. So it prevents hindsight bias being used by judges when directors have acted in an informed way and in a fair way.
Well, Bill, let me ask you this quick, because I do want to make sure we leave time to talk about the Target situation, because I think that's sort of unique and it's sort of exemplary of what I think we're going to see coming in the future. But how about everything that you just talked about are sort of current issues that are in the court? Is there anything that sort of looms there in the horizon that you would say, I think this is something that could crop up in the future kind of issue?
Well, there are a lot of things that concern me a bit, but one that I'll just sort of put on the radar screen for your audience is that I think, lawyers are very enterprising people, and there's going to be an increasing focus, I think, on director compensation. Because after Sarbanes-Oxley, directors' responsibilities and duties are far greater, and the compensation for that should understandably and naturally be greater as well. But when directors are determining their own compensation, it's considered an interested transaction. And ordinarily, the courts will examine interested transactions with much greater scrutiny. You won't get the business judgment standard of review. And so I think that there's a recent decision, or a case rather, filed in the Court of Chancery involving Facebook and the compensation that's paid to the directors of Facebook. And there are some earlier cases that sort of presaged, I think, this increasing effort to focus on director compensation. What are the peer companies' directors being compensated at what levels? Is the compensation pursuant to a stockholder-approved plan? And if it is, then, and it has certain ceilings and limits on what directors can be paid, there's a greater chance the court would apply the deferential business judgment rule standard. If there isn't a ceiling or limits or caps, less likely that the court would do that. More likely it would be considered an interested transaction, making the directors defend it and justify their own compensation.
Yeah, in some ways there's so few that I think sort of fall into that category. It's a shame. I'm sure everybody's going to be painted with the same brush, but
that's what happens.
It's so hard to define what somebody should be paid, you know, for the risk that they're taking and the responsibility.
And I've said before, and you've heard me say, the judges really don't want to get in the business of deciding what someone is worth. They don't get to set their own salaries. They don't really feel like they should be setting someone else's salary or compensation.
Okay, well let's, I wanted to ask you about the Target. We saw, you know, at the end of last year where Target had the case where they were hacked and credit card, millions of credit card information was out in the underground, if you will. ISS had made the recommendation to withhold on some board members. At the time of the show, that has passed. Those board members were re-elected, but by a narrower margin, okay, in that. But the lawsuits are still there, and you know, this cyber security stuff is just, I mean, you and I know that there probably isn't a company that hasn't been hacked. Some know it, some don't know it, okay? But this whole issue with trying to assume what the board should be getting its arms around is just going to be a tremendous challenge. So I'm sure, you know, something's going to end up in the Delaware courts at some point in time centered around this. But when you look at Target, you know, what are their challenges going forward, and how do you feel about this whole liability issue around cyber?
Well, it's a serious issue, and when I talk to boards about this, the emphasis I try to give them is that all companies are at risk of this. All companies probably already have been hacked, as you mentioned, and they just may or may not know it yet. But the issue going forward for boards of directors, I think, is how to protect themselves and their company from this. What kind of structures and processes do they have in place? And more importantly, what kind of record do they create so that they can demonstrate to a court if there is derivative litigation filed after a cybersecurity breach or data breach, there will inevitably be that litigation. And the allegations will be that the board didn't exercise proper oversight. And so the question will be, is there a record to defend the board with, to show that they were involved, that they were asking questions, that they were prepared, that they were overseeing to make sure there was compliance within the organization, and that there was a plan in place in the event there was a data breach or a security breach. And so that's, to me, the real issue. What is the board doing to prepare itself for that day and develop the record that it needs to demonstrate what it was doing and how involved it was in the oversight issue?
You and I had a chance to participate in a panel sort of around this. You had given some keys that boards should be aware of. I think it'd be great if you remember what those were, or at least some of them. I think that would be helpful to our audience.
Sure, I can do that. I mean, just quickly to tick off the ones that I typically try to hit with every board that I talk to is, number one, the board needs to understand its own organizational structures for how to deal with cybersecurity, data privacy issues. That is, what about legal? What about ethics? What about audit? What about IT and IS? Number two, understand how those systems operate. Do they have the sufficient resources? Do they have the personnel and the budget to do the job they need? How do they escalate and respond up the chain about risk mitigation and about any issues that occur to senior management and ultimately to the board? Thirdly, what mechanism does the board have in place to assure its own oversight of this process? Is it going to own it as a board, the whole board going to be involved in the oversight process of risk management with respect to the enterprise as well as cybersecurity? Or are they going to create a special committee like a risk committee to do that? No one-size-fits-all answer to that, but it needs to be there. Fourthly, What are the public disclosure issues, and do they understand how those operate? What is the company saying publicly on its website and its proxy statements about its security systems and privacy and data? If there is a breach, do they know how they're going to respond publicly to the public, to their investors? And then fifth and finally, TK, and perhaps more importantly, what kind of insurance protection do they have for the company and for the board itself? They need to look carefully at those policies. There are now cybersecurity risk policies that are written for this. They need to look very carefully to be sure they're properly protected.
Well, the audience just got a bonus, Bill, because I think that's great advice. It's always a pleasure to have you come on here. Because this is so evolving, we can't wait too long to have you back so that we can see how this is evolving, because it's important to, directors to understand liability, expectations, whatever. So I want to thank you again for giving your time to join us.
It's my pleasure.
And that will conclude this edition of This Week in the Boardroom. We hope you enjoyed the show. As usual, we'll be back again next week, where we'll take a look at another critical topic that'll help you be a better board member or committee member. So we'll see you then.
Join us again next week for This Week in the Boardroom, brought to you by NYSE Governance Services Corporate Board Member, along with Governance Knowledge Partners, the Center for Audit Quality, and Grant Thornton. And contributing partners, National Investor Relations Institute and the Society of Corporate Secretaries and Governance Professionals.